and we are on live. We all the way live.
What's up, family? We got an interesting show tonight with the Pro Se Moles.
Peace.
We're
Exactly.
gonna talk about some stuff tonight. We're gonna get into some meaty, juicy details. We're gonna talk about Terry versus Ohio, family. Terry stops.
Yes,
You want
sir.
to add to this, Mr. Chief Bandole?
All right. All right, y'all. Peace. Peace. Islam. Salam. Hete Pu. Rahubat. We about to get into this tonight. Like he said, we're gonna be dealing with Terry versus Ohio. And so we're gonna look at that, the Fourth Amendment and all that. But look, this is our first show as a pro se moles. All right. So our first show, we're going to be dealing with the as our intro. We're going to be looking in the case of Terry versus Ohio. So I hope y'all enjoy that. Before we get into that, though, uh, you got anything else to say? I'm gonna pull up the screen.
Yeah, I want everybody to go get the book from King El Bey, How to Stop Child Support. How to Stop Child Support. You got issues with child support. I got some information in there that is very suitable for a situation. Um, for more information, you can contact me. Chief. You know,
Hold on. Let me put your
my
stuff up.
books on Amazon. So we got more stuff that we gonna be dropping. We got more material. We're gonna get more and more.
Yep. So check it out. You got King El Bey. His two books, the book on the Morris Blueprint and How to Stop Child Support. I've seen that book, man. You gotta tell me about that, man. We're gonna have to get into that. I
What?
didn't.
Which one?
The Morris Blueprint.
I well, the Morris Blueprint. It talks about the different law sovereignty, the doctrine of law sovereignty, but the book it's not readily available because it has some issues. I'm trying to get it. It was a line all messed up. So when I was looking through it, but that book gonna be out shortly. It's been up. It's been, I guess, it's Amazon got some good advertisement. I caught myself trying to take it down,
Oh, okay, okay.
but then we got the child support manual. Just breaking it down, issues with child support, giving people to understand how to connect the dots with the revised codes, and then like I said, we're going, like tonight we got interesting topics, but these books is gonna be. I'm gonna have more and more available books to show you, more in the blueprint and what's going on, so we can shape everything and put everything in proper context, so we can appropriate. You know, it's called misappropriation of law. When somebody throw law on you that's not geared towards you. So there you go, Chief. Break down the books for
And then y'all check out all my books on Amazon. Navigate Melanated Love. The Melanated Love book right there. That's the new one. And so we going into that. We dealing with our some of our ancestors and some of our melanated scholars, their perspectives on love and relationships in modern time. So it should be a very interesting read. Get something out of it. But you can check out all my books on Amazon. So y'all see what it is. Let's get it. Let's get it. Get it. You know what I'm saying? So let's get into it, brother. Let's get into it, man. We're gonna be talking about Terry versus Ohio. Do you need to put it up on the screen? I do got
that's
it
that's
myself.
that's if you want to pull it up, you know, we can go through it.
Okay.
Or do you want me to pull it up?
I mean, I can pull it up real quick. I'm
Let's break this down, family. For those who don't understand due process and probable cause, let's get into the juicy juice. Juice, juice.
all right. So let's see what this thing was. All right, all right. Terry versus Ohio.
Yeah, I'm gonna break some elements down because there's a lot of more are not really understanding what's going on with this jurisdiction. And I'm gonna go through various points. We'll talk about other stuff in the future because I know some more is gonna be like, oh, I'm not this and that. But we gonna
Nah, this look, y'all, for real. Like what we doing right now is, in order to be competent in the courtroom, you got to know the actual basics. A lot of times we skip over these this stuff because we go straight into sovereign stuff and not connecting the two together. So really, the pro se morals, man, like we gonna break this pro se stuff down. This is for everybody. This ain't just for the Moors. This is really for all our brothers out here who don't have an understanding of the legal system. So we gotta show you how it's done, step by step. So me and King gonna do a series on this. So this is like just really the one out of the whole series. Am I right? I mean,
right. This is the first show together as the Pro Se Morris, and we gonna break this down. I have a plethora of knowledge and of information dealing with these jurisdictional issues and what to do, how to appropriate law, how to really address these issues and really look at them from a very profound aspect. I think a lot of people don't really understand how this stuff works, and they think they don't understand, what's going on. So we're gonna just drop this on y'all head tonight, and we're
right.
gonna get into it.
Please
So,
like and subscribe, y'all. Please like and subscribe.
so when we're talking about this case, Terry versus Ohio, this is a First Amendment application of law. The courts always have to abide by the Constitution. The Constitution is the thing in which the three branches of government they were created from that document. That was the birth of the United States, the U.S., the U.S. S. The corporation, that fiction, that thing that we call the U.S. government. That instrument was the birth of those three branches. The legislative. Hold on one second.
Right. So when he's doing that real quick, I just want you know Terry Terry versus Ohio is like a major case for first of all, right? It's one
Right.
of the major cases. You're gonna learn. When you go into if you go into law school, you're gonna learn about Terry versus Ohio, and one of the main things about Terry versus Ohio is the Fourth Amendment. You know what I'm saying? So, understanding, this case really gives you an understanding of how the uh, the government, how the state looks at the Fourth Amendment. So how you're gonna be able to use that in various type of cases, because the Fourth Amendment is one of the primary amendments that you really need to focus on. You know what I'm saying? So go ahead, brother. Go ahead and you was going in. You was about to go.
So, so when we get to talking about the Terry stop and understanding what the Fourth Amendment is, right, and the elements of the Fourth Amendment, and looking at this case, we got to know case law dealing with the Equal Protection Clause, dealing with the Fourth Amendment. So under this, it says under the Fourth Amendment of the United States Constitution.
Yo, you can pull yours up. Put it on the screen, bro. I'm gonna put yours on there so you can put.
Okay,
Yep.
you gotta take it down. So under Terry, it says under the Fourth Amendment, the U.S. Constitution, a police officer may stop a suspect on the street and frisk him or her without probable cause to arrest if the police officer has reasonable suspicion that the person has committed, is committing, or is about to commit a crime. So this is very suspicious. Because all the officer got to do is have suspicion of these three elements. You either committed, or is committing a crime or committed or is about to commit a crime. How do a person, he has to see. So what do that mean? That mean it has to be in plain view. He has to see you doing something of a criminal nature for him to even approach you, right? He can't just say it's just like if you was drinking something in a paper bag, right? And let's say if it was beer, and let's say you were in the park. If Is that necessarily that you are doing committing a crime? He having suspicions about you committing a crime, but could anybody what makes that criminal? Criminal. What makes a criminal drinking out of the paper bag, right? Has he arrested someone in under the plight or the guise that someone was drinking beer out of a paper bag and was sipping on it and he arrested the person? Or did he smell alcohol? Did he smell the beer reaping from the person pores? Did
Right.
he smell it on their breath? What is the elements that he can identify to trigger that Fourth Amendment application, right? So you got to think about it. There's three portions to this that he has to look at. So when we look at this, you have to look at that. It says it has committed, is committing, or is about to commit. So if you that's just like if you was opening the can of beer in the park, right? Let's say without the being in the paper bag, right? He don't know what you was about to do, right? If you gonna pour it on the ground, if you're gonna drink it, or anything. But it's a crime to open and drink alcohol in public. Okay, you could have been pouring it out. He has to make a sound determination based on his experience and fact that you were going to put that up to your lips or do something illegal with the alcohol, right? He had to show and prove what you was about to do with it. So let's say you open the beer and when he come up, you start pouring it out. Did you commit a crime? What if you found the beer and it was cold and you said, "Well, I opened the beer so I could pour it out and smash it, the can to throw it away, or I collect cans." He doesn't know, so it's going to be how you be able to articulate. That's what I was always good because my mother always told me it was never who told the truth; it was always who told the best story, right? So when dealing with these things, I'm able to. This is a game of wits. You know what I'm saying? Like for example, I had an officer try to hit me with something of that nature. It was I didn't have it. It was a somebody had left a open container. It was in a paper bag on my car. It was a can of beer. And the officer, when we were all standing, right, when he pulled down on us, I didn't want him bothering us, so I grabbed the can to try to throw it away. I told him it was trash. He was like, "Bring me the can, bring me the can." I was like, "It was trash." So he wrote me a ticket for open flask. I had an open container of alcohol in public, right, without a permit. Because you can drink in public if you got a permit. If there's some festivities going on, they allow you to do that. If you've been at a carnival in the city, but you have to get permission from the state to do certain activities like that. So he gave me a ticket. I went to court and I explained to the judge, "Hey, Your Honor, the officer gave me a ticket based on this thing." So when we looking at this Terry stop, we got to understand what is the officer based on his statement? You have to be able to gauge this enough to know what was he doing,
Right.
because we already know they profile a lot.
Facts. Uh, Brother Daoud, I mean, that's, Fourth Amendment, Fourth Amendment violation. It's a fourth. That was, and that's the whole thing. Terry versus Ohio. That Fourth Amendment, man. How did he violate his Fourth Amendment rights? Because he's got the right in his own effects not to be searched or seized.
Right. Or even be detained without probable cause. They have to have something. So you got reasonable suspicion. I don't want y'all to get reasonable suspicion
Right.
confused with probable cause.
Right.
Those are two different elements,
Right.
right? Probable cause is dealing with more of a criminal nature that there's something happened, right?
Right. So
So when we're talking about Terry versus Ohio and looking at this from everything, understanding how this stuff works in relationship with the facts. So you got to know the facts. We got to understand the facts, family. What is the facts? What's going on? So let's get into the case, right? It says the case presents serious questions concerning the role of the Fourth Amendment. So you got to remember this is a question of law. So anytime you're dealing with the Supreme Court, they're dealing with either original jurisdiction or a question of law. Dealing with an application. Do this application fit this scope? Can you use this application in this manner? Or do it violates a person's rights? Right? So it says in confrontation on the street between the citizen and the police investigation suspicious circumstances. Petitioner Terry was convicted on carrying a concealed weapon and sentenced to statutorily prescribed term of 1 to 3 years in the penitentiary. Okay. The denial of a pretrial motion to suppress, the prosecutor introduced evidence of two revolvers and a number of bullets seized from Terry on a co-defendant, Richard Chilton, by Cleveland Police Detective Martin McFadden. At the hearing, the
okay.
motion of suppress this evidence, Officer McFadden testified while he was patrolling in plain clothes downtown Cleveland at approximately 2:30 in the afternoon, October 31st, 1963. The attention was attracted by two men in Chilton and Terry standing on the corner. Now, you remember, these are statements of facts that's going into the record. I want y'all to understand statements of facts. So this either give a preconceived notion of what he was thinking. So based on what the report outlined, you can tear it apart to determine if its proper thought process met the scheme of the application in which he can trigger or use that based on his knowledge and his experience. So standing on the corner of Horan Road and Euclid Avenue, he had never seen the two men before, and he was unable to say precisely what first drew his eyes on them. You understand? So listen to what he said. However, he testified that he had been a policeman for 39 years and a detective for 35, and that he had been assigned to patrol this vicinity downtown Cleveland for shoplifters and pickpockets for 30 years. He explained that he had developed a routine habit of observation, right? Observation
Right.
over the years, and that he was would stand and watch people or walk or watch people at many intervals of the day. He added, now in this case, when I looked over, they didn't look right to me at the time. You see what I'm saying? He just saying they didn't look right to him. He
Right.
didn't see no crime. He didn't see anything. He just said these people didn't fit. He just felt like these people didn't fit. His interest aroused Officer McFadden took a post of observation in the entrance of the store of 300 to 400 feet away from the two men. I get more purpose to watch them when I seen them in their movement. He testified he saw one of the men lead the other one and walk southwards on Herman Road past three stores. The man paused for a moment and looked in the store window, then walked on a short distance, turned around, and walked back towards the corner, pausing once again to look in the same store window. He joined his companion at the corner, and the two conferred briefly. The second man went through the same series of motions, strolling down Herndon Road, looking in the window, walking on a short distance, turning back, peering into the store window again, and returning to confer with the first man at the corner. The two men repeated this ritual alternately between 5 and 6 times apiece, in all roughly a dozen trips. One, it says at one point, okay, stop doing that. At one point, while the two were standing together on the corner, a third man approached them and engaged them briefly in a conversation. This man then left the two others and walked west on Euclid Avenue. Chilton and Terry resumed their measured pace, peering and conferring. After this had gone on for 10 to 12 minutes, the two men walked off together, heading west on Euclid Avenue, following the path taken either by the third man. They said this time the officer McFadden had became roughly suspicious. He testified after observing their elaborate call of casual and oft repeated reconnaissance of the store window on Horan Road. He suspected the two men of casing a job, a a stick up, and that he considered it is his duty as a police officer to investigate further. He added that he feared they may have a gun. Thus, Officer McFadden followed Chilton and Terry and saw them stop in front of Zucker's store to walk to the same man who had conferred with them earlier on the street corner. Deciding the situation was right for direct action, Officer McFadden approached the three men identified. So this was his whole point. He saw him looking in the window, kept looking, going pacing, looking in the window. So he thought they about to jack the store. That was his whole premise. He's seen two men pacing back and forth, looking in the window. So he said, "Oh, they about to rob."
Right. But that's how police are trained too. Always investigating.
So he didn't see a gun. He didn't see nothing what they call plain view. They didn't. So let's go back to the elements of what was necessary under the Fourth Amendment. It was three criteria, right? It was has reasonable suspicions that has committed a crime, is committing a crime, or about to commit a crime. So what gave him the mark that they was about to commit a crime? What did he observe that they was about to do to commit a crime?
You mean the suspicion? What was suspicious? They said
But
suspicion
even
of a person.
Right, but
That's about to suspicion that is about to commit a crime.
right.
So
So,
so what was the elements? It was the way he felt like they was moving. He
but
had suspicion of them that they were going to rob the spot. I'm saying that's kind of how they coming at it, in my opinion, right?
right, he had, but here's the problem with that, right? Look at is looking in a window a component of committing a crime? Because we got to look at these three elements again.
Not in itself, but he's saying like they kept going back doing this and that, and he never seen them before, so it gave him some kind of did
It-
that give him reason? Did that give him reasonable suspicion? That's what I'm
but
saying.
that's what I'm saying. But when we say reasonable suspicion, we have to look at what elements, because when we look at that, there has to be criminal elements inside of this before the trigger the Fourth Amendment for this reasonable suspicion to be triggered.
Okay,
He never seen a weapon, right? He never seen a weapon. He never seen them attack anybody or get aggressive or grab or assault or choke or implement.
but like we said, probable cause versus reasonable suspicion. Are you talking about probable cause more than you talking about reasonable suspicion? Because I feel like probable cause is the more secure right, and then reasonable suspicion is something they snuck in there, eating away at the Fourth Amendment.
But
Like,
even when we talk about reasonable suspicion, it still have to be conspicuous to a degree. There has to be something that identifies some wrongdoing.
okay,
It has to be a little bit of tangent. So if I had a gun, if he's seen I seen a bulge in the shirt, and when he moved, I seen a gun handle. That would trigger reasonable suspicion.
okay,
Just because I got a gun don't mean I'm committing a crime. You don't know who I am, what I am, and with the gun, if the gun is registered, illegal, or whatever, you don't know anything about the gun and the status of the gun to determine anything. That has to be determined with the investigation. Because what if I had a gun, a carry to concealed weapon, and I had the gun at the time in my waist, right? I'm allowed to do that. And if I have no priors, then it's nothing illegal. So we have to look at all the components that's necessary with that. But since he has to prove, okay,
right. So let me see if I can share something real quick, though. Let me share something real quick. All right, so looking at reasonable suspicion, right? Reasonable suspicion is a standard used in criminal procedure. Reasonable suspicion is used in determining the legality of a police officer's decision to perform a search. When an officer stops someone to search a person, courts require that the officer has either a search warrant or probable cause to search, or a reasonable suspicion to search. So it's an in descending order of what gives an officer the broadest. This is broadest authority to perform a search. Courts have found that the order is search warrant, probable cause, and then reasonable suspicion. Okay, so let me go back. Um, I'm trying to hold on. Let me see. So
might as well finish that. And Terry versus
Yeah, I'm gonna go back into it. Okay, so Terry versus Ohio, the Supreme Court held that if a police officer believes that an individual has a weapon which poses a danger to the officer may stop that individual to search the individual for a weapon. Okay, so before I like right there, he didn't have reasonable suspicion yet based on what we had read. Would you agree?
of course.
Okay, so the
But then
court
it says, go
uh,
ahead.
no go okay. I was going to read the last end of it. The court held that to determine whether the police officer acted reasonably in the stop, a court should not look at whether he has a hunch, but rather to a specific reasoning, a reasonable inferences which he is entitled to draw from the facts in light of his experience.
That's the element. That's the key that I'm
Boom.
talking about. Boom.
Boom.
He has to draw from a particular facts and experience. That's what I was saying. It had to be based on something concrete, not a hunch. These two brothers walking down the street, I believe they got a gun. It he did there was there a bulge that looked like a gun handle? Did he see me lift up my shirt and he seen a gun handle, which then he had the right to approach me? Did he see you hand me a gun? You see what I'm saying? While we were in the car. Um, these are the things that brothers and sisters need to understand.
Right. Brother Daoud, yes, you bros are spot on. Keep up the good work and keep your spirits up. Yeah, brother. Like I said, it's our first show trying to do it from this angle. So, we bear with us, but we want to give the basics, you know. Uh but you got another one I see you put up here. Uh Look up the Sullivan Act from New York, and it says that it overturned this law, and it was a federal ruling. The Sullivan Act was rooted in racism to disarm certain groups of people like Italians, etc. Okay, are you familiar with the Sullivan Act?
Now I'm not, I'm not in New York, so I'm not really familiar. But when you look at the various of degrees of the application, let's go to the Fourth Amendment itself, right? Let's go to the Fourth Amendment. Let's go to the Fourth Amendment. Let's break this down. So we're talking about an application of law, right? We're talking about application. We're talking about how did this person get this right to activate this application. This is an application in regards to the jurisdictional prowess of the court in making a legal determination. So I always, when I look at statements, I break it down because I already know how to look at things. Having the years of experience of what I have, and I try to tell people it's all about. It's about. I tell people, you know, anything you say can and will be used against you. So um, it's better not to say anything and allow them to do all the talking and chop their head off at the stand based on the stuff that they try to utilize. But it says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So there's some wordplay, there's some moving parts in this that we have to look at. So first of all, people have a right to be secure, right? And their persons, right? Houses, papers, and effects. So you have a right. This is the Fourth Amendment. everybody try to act like this is a security agreement provision. All you guys who are secure party creditors, this is an element of a security agreement, securing your rights. This is an action of security. So, and then it says against unreasonable searches and seizure. What makes something unreasonable? Somebody not having any facts. If I don't got no facts on nothing, that is blank out unreasonable. You cannot determine that I'm a criminal based on my color, or I'm about to do a criminal act based upon my height, based upon how I talk, based upon how I look, based upon how I walk. None of those are elements that give you reasonable suspicion. Okay? Wearing a even down to if it's if you got a ski mask and it's on in the summertime, that's one thing. But what if it's wintertime and you got on a ski mask? Look at everybody wearing these masks. What about having on a hospital mask now that this COVID stuff exists? Now, do that qualify as reasonable suspicion? You see what
I
I'm saying?
mean, the Constitution doesn't even say anything about reasonable suspicions.
I know it says unreasonable searches. It don't even they put that in there. They threw that element in there, right? The Fourth Amendment don't even. That was some case law that they added some elements in there to give them some headway.
Right.
You see what I'm saying? They had to justify what police were doing, right? They had to go in and look at that. But even if you're looking at it from a very articulated standpoint, we have to still look at what is he drawing his conclusion based off of. It has to be something that is a requisite that, based on his experience, that deals with a particular legal situation that somebody was doing something criminal. You see what I'm saying? So where's the criminal elements? It has to be some criminal elements that he has to be able to see in plain view. There has to be something. He can't draw a conclusion about color, weight, height, how when someone talk, how someone look, what someone's wearing. None of that is an element of anything. If you got on gloves, if you don't got on gloves, none of that gives someone reasonable suspicion.
Okay. So, all right. I want to
Looking in the window is not reasonable suspicion.
no.
Now, if he would have heard, hey man, I think the cashiers went to the back. I think it's time to we could go in there with the pistols to rob the store. Now that's different.
So, look what they say in this. Right. No right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraints or interference of others, unless by clear and unquestionable authority of law. And look, that's from 1891.
Right.
By common law, it says. By the common law, the right.
Right.
Terry, the Terry basically overturned this in a
Right.
sense because this is very secure in this right. Uh, Terry, it's very like broad on the policing powers that they have. Reasonable suspicion is such a vague terminology. It grants the police a lot more wiggle room, if you will, to be able to make an arrest. You see what I'm saying?
Well, it's not so much to make it. They have the right to search you, pat you down. They just can't. They can't do what they call an intrusive search. They can do like a pat down, or they can ask you questions. Where you going? Give me your ID. That is a form of search and seizure.
Right, but so
Reasonable suspicion.
if a brother walking down the street, he could just be like, I mean, that's what he's doing. He like, hey, you look suspicious. What's the first thing they say? Oh, there's a robbery in your area. You fit the description.
That gives. I mean, that gives reasonable. They give them.
And
They
see,
give
that's what I'm. But that
reason.
gives them too much wiggle room. That's what I'm saying. Like Terry versus Ohio, and a reasonable suspicion. That's some.
But the facts still got to stand true. If there wasn't a robbery in that area and he lied based upon those facts, then you can get the case thrown out based on his own verbiage. He lied, said there was a
He
um
says he says the two men repeated this ritual between 5 to 7 times apiece.
right, but I was talking about the statement you said if the police officers say that it was a robbery in that area.
Right, right, right.
It has to be now we have to say, okay, was there really a robbery? Now we can pull up those records. If it wasn't, we know that he was lying, that he was drawing some kind of he made up so he made up a story now to stop you to give you that. And a lot of times your attorney won't even bring that to light.
I got you. And that's like the poisonous tree doctrine, right?
Right.
Okay. I got you. I got
Right. So he made up a story to fit a scheme, right? To now intrude on your rights, which is a violation of the Fourth Amendment, right?
you. Right.
So
That's it. Right.
so a lot of people, just to put this in perspective, we have to collaterally attack what's being stated. You got to hit them at all angles. So what would I do in this issue? Okay, if the officer said there was a robbery, I asked for a motion for discovery, requesting the report of the area of the crime that was supposed to be committed. Right? So I would need that in the form of discovery. If none exists or if it's unavailable, then we can assume under this position of law that the officer was being untruthful. He wasn't acting in good faith.
That is true, y'all. Y'all hear that? That's true. That's how you use a discovery. That's how you use a discovery, yo. So check.
Oh, King El Bey. I told you we get in that courtroom. I get the. They were like, "Here comes the Terminator."
Now this hey, here he comes. Johnny Cochran reincarnated. Johnny
Baby.
Cochran reincarnated. Nah, but for real, okay, so like right here it's talking about like so after that clear understanding of what our rights was under common law,
Right.
then it's like we have recently held that the Fourth Amendment protects people, not places. And whenever an individual may harbor a reasonable expectation of privacy, he is entitled to be free from unreasonable governmental intrusion. Of course, the specific content and incidents of this right must be shaped by the context in which it is asserted. For what the Constitution forbids is not all searches and seizures, but unreasonable searches and seizures. Unquestionably,
Hold on,
partic-
hold on. Go back,
go
go
ahead. Busted, busted, busted. Go
It
back.
says, so I want y'all to look at how the language is worded. What
Yes.
the Constitution forbid is not all searches and seizures, but unreasonable searches and seizures.
Aha. Right.
You see what I'm saying? I want you, the devil is in the details. I want you to understand the undertone of what is what. So the Constitution, they saying, look, it didn't cover all searches and seizures. It just covered unreasonable searches and seizures. So what is the searches that they're referring to, right? You see what I'm saying? That's outside the scope of that application under the Fourth Amendment.
Right. So the question is whether, in all the circumstances of this on the street encounter, has right to personal security was violated by an unreasonable search and seizure. Okay. So,
So, what would we look at as a search that would qualify as a reasonable search? So, this is what I was talking about. The officers asking you for your ID. You, like in our state statute, you're required to carry some form of identification,
papers, please.
right? So, but we got to look at the scopatory of the what? Of the law according to what? That law, Ohio Revised Code, a person required to carry identification. What forms of identification? The language and specifically, could an affidavit of identity fall under that application? Could a business card fall under that application of being identified? You giving the officer your name is a form of identification. What qualify these different forms of identification, and what disqualify it as unreasonable in a sense where the officer is outside of the scope? So now we got to measure the two. What is reasonable that covers within that's outside of the Fourth Amendment, and what is unreasonable due to the nature and character of the Fourth Amendment application.
I got you.
You
So
see what
look,
I'm saying?
so basically in here it's saying on one hand, it is frequently argued that in dealing with the rapidly unfolding and often dangerous situations on the city streets, the police are in need of an escalating set of flexible responses graduated in relation to the amount of information they possess. For this purpose, it is urged that distinctions should be made between a stop and an arrest, or a seizure of a person, and between a frisk and a search. Thus, it is argued that police should be allowed to stop a person and detain him briefly for questioning upon suspicion that he may be connected with criminal activity. So this just takes me back for a minute. Like, when people get stopped and they say they don't have to answer anything. But if it's a crime, if he suspects a crime, then they're saying that you should be able to question that person. You should be able to.
No, that's not even that what that's saying. We got to dial it back some. I want you to go back into let's look at this. This says if it's I want you to look at this very deeply. This you ain't got to be doing no kind of crime. This is just an officer has the right. under these elements of with outside these are outside the scope of the Fourth Amendment that he has a right to what they call reasonable, right? Suspicion that's outside because the Constitution only deals with what? Unreasonable searches and seizures, but not reasonable searches. That's an element or a gambit outside the application. So what we need to identify what are those things that they consider outside the Fourth Amendment for as a person asking for as those being within the right of an officer. So like I said, you said if a person says, hey, I don't have to answer questions, right? The officer has the right to ask you, he has a right to ask you to identify yourself.
Right. You have to identify yourself.
So that's reasonable. That's a reasonable thing. You ain't got to be doing no crime. He could just walk up to you and ask you, hey, you got any form of ID?
Hold on. It says, okay, well, it says a person detained him briefly for questioning. Listen, upon suspicion that he may be connected with criminal activity. So there's a suspicion of criminal activity that he's going to have in order to stop you. That's what I was getting from that.
That the police should be allowed to stop a person and detain him briefly for questioning upon suspicions that may not be
No,
connected
that may be connected.
or may be connected with criminal activity.
You see what I'm saying? So yeah, he'll stop you if it's based on some kind of criminal act, but he can't just stop you and just be like you walking down the street. Hey, give me your ID. You haven't done anything that's suspicious to cause him to stop you. He
I
has to have some suspicion, right?
I had this happen to me before, right? An officer had a picture. He looking at a picture, and he said, "I look like that person in the picture." And I'm like, "I don't look nothing like." He was just lighter. He was just me and him was about the same complexion with the same kind of haircut. But he's like, "Oh, I thought this was you, right?"
Right? Mistaken identity. I mean, he could have mistaken identity. Now, I got something, Brother Daoud was saying. You may say, I invoke my fourth, fifth, and 14th Amendment rights, right? And I so not consent to a search and seizure of my person and property. Have that documented with video, then qualified immunity is lost. Now, I'm going to tell you that's true. And I'm going to tell you, though, from a personal experience, to have a search and seizure, getting stopped, and they then try after a traffic stop, they push the case further. You know, officers trying to smell something in your car. You know, they say they smelled something in my car, and they gave them the right to get my car. And I still wouldn't let them in my car. I said, nah. I said, I stand on my fourth. I invoke my Fourth Amendment. I was like, no, I do not consent. I said, I do not consent to searches to the car. I told them that. So they still took me out the car, and they handcuffed me, put me in the back of the car, went into the car and searched for something until they found something, and then gave me a ticket for it. Now, even though they said they had probable cause or they had reasonable suspicion to look in my car, I still got a suppression hearing for that case. You know why? Because I never consented. So even though a police officer might go and make his own interpretation of what he wants to do, if I don't consent, because a lot of times that's what brothers have done. A brother might let the consent to going in the car, and then they find something, and now they don't have no remedy. They have wavered their Fourth Amendment right. So you know what I'm saying? Uh-oh. I see you.
Now, no, I'm cool. I'm cool.
But go ahead.
I like what Dawu said, right? and I'm gonna tell this for everybody. You should, anytime you get approached by an officer, you should cut on your cell phone camera for your own safety and the officer's safety.
Yeah, true.
You should ask them, and I'm gonna tell you what another thing. If you have, you should let them know this is automatically being recorded for what they say on the phones for uh is it qualified purposes for when they say this telephone call is being recorded for when you get those for quality insurance, right?
Yeah.
You should automatically let him know, hey, Your Honor, officer, I had to record this for because I'm on a contract for qualified for quality insurance. So if you mind when you step into me or approaching me, I have a right to cut on this camera, right?
Yeah.
You can invoke that right. He can't take that right. There are a lot of times they'll try to take your camera and impede on your right. That's another violation of your rights.
Yeah. So I suggest too that you make sure it go into a cloud. It's going to a cloud somewhere, or it's going somewhere where it's being recorded
Right,
away from that camera. You know what I mean? Because
right,
if they take it, you still got it. So
right.
yeah,
So another thing, I mean, I like what he said about the fourth and the fifth. That you're going to invoke your right. Okay, under that, right? You invoke that right. But we also, like in your case, there are a lot of times they'll say they found marijuana or that who says it didn't come off your shoe? Who said that you didn't step on somebody spilled some marijuana and a marijuana seed was stuck in your shoe or it didn't you stepped in some marijuana? Who says you didn't? Who
yeah,
says who says you weren't coming from an apartment building and somebody spilled you say, man, hey, somebody has spilled some marijuana on the ground. I tried to step over it, I might have stepped in it.
right.
Who knows anything? So when we're dealing with these facts, all of these things got to come up because the officer is making an assessment. When he come in the car, if he say like, because they love to use, I smell marijuana.
Yes, that's
That's
it.
what they love to use.
Yes,
So, like one of the things I beat the case on that dealing with smelling marijuana. So we wanted to ask, okay, since you're saying you smell marijuana, okay, tell me, okay, how for sure it was marijuana. Is there any other substance that burns that smell like marijuana? Do burn grass smell like marijuana? So when dealing with this, right, when we hit them with the discovery and requested certain things, the officer relied on his experience and said, well, I use my experience to identify the marijuana. I felt like I smelt it. And so he wanted to come and do a search. So he said it smelled like the person had marijuana. So I think it was more. I used the case. It was Moore versus Ohio. Or it's another case that I found where a gentleman had been at a party and they had been smoking marijuana and it was in his clothes. Right? So the officer didn't distinctively determine where the marijuana came from. He said he smelled marijuana. The gentleman said and the argument was that was it coming the gentleman said it was in his clothes and not in his car, and based upon the officer had smelled it on his person, it directly wasn't coming from the car. So they dismissed the case on the grounds they they suppressed the evidence of the officer's statement on the grounds that it wasn't qualified because the officer didn't make a distinct um qualification that it came from the person or that because of if I'm at a party and people are smoking marijuana and it get in my clothes, right? It can that can make a determination. So it's all types of ways to disqualify this immunity when officers are not very articulated in their argument, in their approach of making a claim, right? So if he's saying, "Oh, I smell marijuana," and I say, "Well, I came from a party," them guys were smoking. I tell my lawyer that, and the officer don't make a distinction that it was coming from the car itself or the person. And that's why I said I think it was a case Moore versus Ohio where the gentleman got his the officer's statement suppressed because he was at a party. Like I said before. He was at a party. And they suppressed the evidence on the fact that he said, "Man, they was smoking marijuana," and they went and searched his car and they found some drugs. They didn't find marijuana. They found some pills. Right? He had some pills in the car. He had he had some pills that wasn't. He had some narcotics. I don't know if it was in a pill bottle or anything like that, but he got the case dismissed on those elements, and because it wasn't like they found marijuana. Now, if they would have found marijuana, that would have been one thing, but they found pills, and they charged him with possession of carrying a narcotic versus marijuana. You see what I'm saying? So by him saying, "Hey, they smell marijuana on me because I was at a party," that the officer didn't articulate that it came from the car, and they never found any marijuana cigarettes or anything like that to determine that there was burning marijuana in the car, right? He got it suppressed.
Hey, and to even add to that, if you guys do have something in the car, even though, and you know that, you still don't consent
to search.
You do not consent to search for no reason whatsoever, especially if you got something incriminating in your car.
Oh, and then on top of that, you don't say nothing at all when you get to the police station. Just shut the hell up.
Yeah, because all of that's a violation of your Fifth Amendment.
Exactly. So you want to always invoke your Fifth Amendment, right, regardless of what's going on, and make them do their job.
Exactly.
You see what I'm saying? Because what I have discovered that they always take shortcuts.
Exactly.
I found that these departments always find a way to take a shortcut.
Yep.
And if you do a proper investigative search on the matter through your discovery prowess, utilizing certain techniques of discovery, you're going to find where they did something where they broke the law to try to enforce it. And it may fall under the scope of fruit of a poisonous tree under that application where you can get your case either suppressed, right? And on your motions, and you got to make sure you know how to plead, make sure that you know how to object to preserve your rights under plain error for appeal. And I tell people all the time, you got to learn how to shut down the court. When the court is acting stupid, you got to learn how to file an injunction. Take the action from that court altogether. Hold up. Y'all want to play this thing? Y'all want to violate due process? I'm going to strip the court of its ability to make a ruling, and and I'm gonna take it to the appealing court. Strip them under an injunction, right?
Yep.
You hit them with the notice of filing an injunction, ask for a motion for a stay of trial or
So you,
stay of hearing, right?
yeah.
And just go straight to the injunction and hit them with the probable cause issues. That the court is not honoring probable cause and they're stripping you. And now you let the appeal court and you just bust them on that error. When they're being Andre. When the judge is being Andre, he's being unreasonable. He's not honoring your due process. You go ahead and strip him of his powers and take it to a higher court that's going to look at it on an en banc hearing.
Right.
Y'all, they ready for this? Do they really want some of this pro se modes?
They're not ready for these pro se modes. They're not ready for these pro se modes. You hear
So,
me?
so
But you know what? Y'all gotta look at attacking reasonable suspicion. That's what you basically trying to knock out of court is their reasonable suspicion. If you can knock reasonable suspicion out, it's over.
it's over. If you can
It's
knock
over.
out probable cause, it's over. If they can't articulate a particular thing, action in which it had criminal elements, right? Like and they use it like I told you. Their favorite thing is I smell marijuana in the car. I smell marijuana in the car. I smell marijuana. I smell burn. See, they don't say. They like to say like, and this is how we got the case overturned because he said he smelled burning marijuana. He smelled
That's
burnt marijuana,
right. That's what they said.
right? So when we hit them with the suppression and everything, they didn't, and we hit them with the discovery. There was no marijuana that was ever they found burning in the car. So we know there was a fallacy
Just
that he made that up.
just remember, you cannot get a suppression hearing if you consented to search. I
You
just want to tell
cannot.
them you can't get a suppression. It's very difficult if you consented, if you gave him permission to search.
Well, it has to be. Let me just say this.
I say it's very difficult.
It's
I'm not
difficult.
saying it's
Let me say
impossible.
this. Let me just say this. If you consent to search, let it not be recorded. If it's not on the record, if they ain't got a video hearing like they like to do, and then like I said, a lot
They
of
always they got them cameras on them.
right, but
So
they
don't do it. Don't do it.
don't
All I'm saying is don't
don't
consent,
do it.
y'all. Just
Don't
don't consent.
don't
Period.
pursue it. And then on top of that, you got to hit them with the motion for what discovery you want the MKT and K.
Oh,
Yeah,
you going into see we ain't even got it to see. Look, y'all.
I ain't gonna go in there. I ain't gonna go in there
We
yet.
we gonna stick on pro. We gonna stick on
No,
this topic for today. We're gonna have several episodes,
right.
but we do want you to understand the Terry case. We want you to
Yeah,
understand Fourth Amendment. You know,
right.
we gonna talk about First Amendment. And all the
We're gonna break all this stuff down. We're gonna
right,
show you how to connect the dots. How provision, the dynamic duo in the building, right? How to break this down and articulate facts. I tell people law is very absolute and specific. So for officer, like when we was doing the discovery, he said he smelled like burnt marijuana. And so in the discovery, we showed there was never any burned evidence of burnt marijuana. So we won the suppression based on several grounds that he articulated that there were burnt marijuana. It smelled like burnt marijuana. He didn't say it smelled like marijuana. He said it smelled like burnt marijuana.
right.
Like somebody had been smoking marijuana.
So how'd you? I mean, you come on now. What you tell them then, man? Like, I mean, something.
So when we hit them with the motion for discovery, we asked for the discovery evidence or the evidentiary evidence that showed that there were any form of evidence that there was any burning marijuana in the car. And it came out unconclusive because they had never possessed any evidence that showed that there were burning marijuana.
But so so did they have any marijuana?
Yeah, he had some drugs in the car.
So he had what you call drugs
He had
in
some
the car.
drugs, and it was marijuana sealed up with some other drugs.
Okay.
But they said and articulated burning marijuana. So we proved there was no burning marijuana. Everything that he had was concealed.
Touche.
So we suppressed it. So without the reasonable suspicion and probable cause, they had no case. So we knew that they was reaching. They was trying to use some stuff. But because there wasn't, and since the offer, the drugs wasn't in plain view, right? That they had to also have where they had to see it. They went through his car and searched it and found the drugs. With and you see what I'm saying?
I got
So, but that's what he said. Hey man, I smell marijuana. Can I check your car? He hadn't been smoking no marijuana. There was no evidence that he had any. He said it smelled like burnt marijuana. It smelled like somebody was smoking marijuana, and they use that all the time. And we just showed that there wasn't no evidence of any burning marijuana.
exactly. But see, like even with other stuff, like like just say you get stopped because a lot of times you get stopped. Like we've seen it before. You on the highway. You,
Driving while black.
you yeah, driving while melanated, and then you get pulled over, and then they start asking you questions, get you nervous. Then they hit you with, "Can I search the vehicle?"
You know how they do it? They say, well, his artery was pumped.
Yeah, that tell you. Look, that's the number one thing. My arterial coronal artery was bulging out. That let me know that he was suspicious. These are vague things. Like these are things that are very hard to prove in court that we allow to even
Right.
go into court. That shouldn't even be allowed in court. That's no proof in that. You should
But
object. Like that's an objection.
no, but see, they'll use that to say that they're expert on this, right? But how do anyone ever challenge their expertise? So, will do anyone ever say, do you have a medical degree that can substantiate your expert?
Right, but that's my objection. It's gonna stand on. I object. Do you have experts or any evidence right now? Then nah, I object. I object to
Because
you.
they use that. Oh, he was sweating. He
I
was
know,
this.
but you have to object. You have to object to it.
You have to object. You have to disqualify that statement.
Hmm. You have to get that stricken from the record. For real, like that's what y'all like. If you're going to object, you have to object to things that you know that they're saying that they don't have any proof for. You
You
know, he
have.
ain't got proof for that. You got to object to that.
This is why you have to have. So one of the things that I like to use, right, is interrogatories and admissions in the criminal proceedings. That's where this come in Ohio. Interrogatories and admissions for the degree of this, so that you can have them on the record prior to anything, and you tell the court, hey, we trying to save taxpayers dollars, Your Honor, under this application of interrogatories and admission. I would like to use this to save time and energy so that the officer has a duty versus having to cross-examine him and do all of these things at the hearing, right? When you can do all of this at the pre-stages, right? At pre-trial, as an evidentiary tool to disqualify the officer. Sometimes the judges uh, tell you no, but then you ask him, "Hey, Your Honor, could you identify the conclusion of fact and law why you disqualify such thing?" You have to understand what to do.
I got you. So, y'all, we got a few more minutes left on here, right? I'm not gonna stay on here too long, but we do have a few more minutes, man. I wanted to see if we exhausted everything we need to speak about on on this case because we, like right here, they're talking about. They say our first task is to establish at what point is this encounter the Fourth Amendment becomes relevant. That is, we must decide whether and when the officer McFadden seized Terry, and whether and when he conducted a search. There is some suggestion in the use of the term stop and frisk that such police conduct is outside the purview of the Fourth Amendment because neither action rises to the level of a search or seizure. See, now, I'm going to stop real quick because, like, search and seizure is in the Constitution. It's in the Constitution, right?
Right?
Okay. But stop and frisk is not in the Constitution. So, you
So
know,
you
right.
you,
Wait.
you gotta look out what they're doing. They play on words. They're using terms that's outside of the gambit of the Fourth Amendment to
Mm-hmm.
utilize them saying that they have a right to do a stop and frisk because the Fourth Amendment deals in unreasonable searches and seizures. And since the Fourth Amendment under its application don't use the phrase stop and frisk, then it's outside of that application, right?
Yes.
So looking at the clauses and provisions of anything, you got to look at the language. Language is very important. I tell people the devil is always in the details. So remember, we talk about this all the time. I say if it's not in it, then it's not applied, it's not applicable. If it's if it's not in the contract, then it's not applicable, right?
Right.
So stop and frisk is outside of that, and that's what they like to do. Okay, we did a stop and frisk. That's not an unreasonable search and seizure. It don't follow under the gambit of the Fourth Amendment.
Right.
So they can exercise that power.
So let me ask you this: wouldn't that be under color of law?
A colorable action of law.
Wouldn't that be color of law?
Yeah,
I'm just saying.
right.
It's like they pulling you out of the constitutional jurisdiction, right? Which we're not gonna get too deep, but I'm just saying, like they're pulling you out of a constitutional jurisdiction and putting you into a, a statutory or non-constitutional, if you would.
Well, they're finding ways to get around the constitutional language, right?
Exactly. So, but it says so. They're saying so. What they're saying though is, in this case, there can be no question then that Officer McFadden seized petitioner and subjected him to a search when he took hold of him and patted down the outer surfaces of his clothing. We must decide whether at this point it is reasonable for McFadden to have interfered with petitioner's personal security as he did. Right? So, I mean, like, this is why this is why case law is really important because they give you a real life scenario. You know what I mean? They give you a real nice scenario, and I appreciate brother Daoud, bro. Appreciate brother Daoud for coming on and being in here tonight. You bring a lot of good points to the table tonight, and hopefully we'll draw more people in. That's bringing some more information as well. So
we're gonna stay on this topic. I think the next approach, because I want to get into military coercion. I want to bring in all the other elements, stuff that they need to bring into. We want to bring in the selective service, adjunct general, and how they're establishing jurisdiction to even tie you in to the Constitution under their administrative law. So we gonna break it down for y'all. We're gonna bust it down.
yeah, hopefully as we go into this, with each episode we go unfold this. I just like I said, it's important for us to understand for the people coming in because, like I said, man, a lot of people coming into this movement, like you know, with the sovereign stuff in mind, but don't understand the laws, haven't looked at any real case law, haven't broke it down. They kind of just running off of what they done heard in sovereignty. They reading a lot of sovereign literature with not a real application to it. It's hard for you to put it in the court, and it's hard for the court to really understand any of that.
But this is the thing: they don't know how to take the face off the jurisdiction. They don't know how to pull the mask off. They don't know how to make certain discoveries and make certain articulate certain pinpoint certain elements where they can disqualify the jurisdiction. They don't know how to do that. A lot of people challenge the jurisdiction. They don't know how to disqualify it by looking at all the elements and showing where they don't know that the that the institution did not sink its teeth into you to gain jurisdiction by having certain things in place. They don't understand this stuff. So we're going to give you some things to help you expose certain facts and certain do the lead work on some of this stuff because we through this process of me studying and exercising these powers that I do now possess, you know and it is and I beat them so many times on due process. I don't argue nothing but due process issues. The last time I've been in court, beat them on some due process issues. Got acquitted
Yeah,
on being able to articulate certain facts.
yeah.
You see what I'm saying?
We've done shows on them too. Y'all check them. Y'all go back into the backlog and check out some of our old shows. Like I said, please like this video too, y'all. Please like the video and share this video.
So now we gonna give you some elements like when they say they smell marijuana. Make them identify what when you say smell marijuana. What do you mean by
I
smelling?
mean, but like even with that, marijuana is changed. The laws have changed around a lot of different states now. So they're not really tripping as much on that anymore. But like, let's say, like even with a gun, you know, having guns or other contraband and getting stopped by the police because you know they see you coming out of a shady area. Well, that's another case. Remember that case in Cincinnati where the brother was in the over the Rhine?
Um, um,
I
what
was
happened?
somewhere, but he gets stopped and they wound up finding something in his car and they got him. But it was like it wasn't. He didn't smell anything, but he saw him coming from a known trap
Drug.
house. Yeah, found him coming out of a trap, and he stopped him because he figured something was on him. So things like that have to be looked at as well. Like how you dealing with And there's a case. There was cases that we looked at. Me and you just looked at it. I know we looked at a lot of cases. So
Right. So things that when there's a high traffic area, but the thing that you have to be articulate because okay, my mama who lives down there. I got family. You're not allowed to visit those areas with high crime and high drug areas. A lot of people live in those areas. What are you supposed to evade those areas when you don't have family? And the officers say, well, he came out of this well-known trap spot or a high traffic drug area, so they give me the right to stop him. So first, that's why I say it's good to use interrogatories and missions in these aspects under Ohio Rule Criminal 59. In some other states, there's others that tell you that where there is no application under the criminal rules, you can seek to utilize the civil rules of procedure, and that's one of the elements I'd like to use because. And then I hit them with a motion for sanctions. Why would I hit them with the motions to sanctions with the interrogatories and admissions? Why? Because we're talking about speedy trial. The officer, he's gonna make a claim. We need to get certain facts articulated on the record so that we can do a proper investigation. I don't want to wait to cross-examine him at trial. I need these facts now so I can fact check everything he said. So under the rule, it's an appropriated application. It's an appropriate application to utilize the civil rules in this manner to articulate what was the officer thinking at the time, so that we don't. So we have to wait to trial to get all of this done. No, I want to get all of this done before pre-trial to determine what is going to be used at trial and if we're going to have trial at all. These are
y'all,
things that you have to understand, family. I've been doing this for a long time. I'm young Johnny reincarnated, baby. I'm just telling you, I'm dropping gems. You
right,
have to learn how to utilize these things. And these are things that I have used to win cases.
right, right. So that's why we. That's why I'm saying like we want to leave like a nice little record of pro se talk because for one we not lawyers. Y'all go seek a lawyer for legal advice. This is not legal advice. This is edutainment, and for education and entertainment purposes. You know, but we want to leave a series of these for everybody to go back and have record of this kind of stuff. And
Right.
y'all check out indigenousmoors.org. Also, that's where we got a lot of the legal information, legal books, like just the basics. Um, like I'm telling you like this. A lot of sovereigns be like can can rattle off stuff, but don't know. They don't even know the case. They don't even know the code that they being charged with. They don't even know what they being charged with. They just go in there. They ain't even looked up in the book what the code was. What was being charged with. They just jump straight into sovereign and say they're gonna file a whole bunch of affidavits and be free. And I swear by it. And but there's building blocks missing. You understand? There's a lot of building blocks that's missing from that, and I understand it because I came out that way. So
Right. And then a lot of times they don't. It's like they don't even know how to really have the legal IQ in the courtroom. They don't know how to utilize all of these dancing partners. Like a lot of people don't know, you can use the attorney as a witness. You can utilize the attorney as a witness. You don't have to argue statutes and codes. You can argue your religious rights versus the statutes and code. But how would you use the statutes and codes? They will be exhibits into evidence.
no doubt, man, no doubt. Well,
So, family, we have a plethora of techniques and stuff that a lot of people just ain't use. Utilizing the Constitution as evidence, and then you allowing the prosecutor as that to be as an exhibit and use it as an exhibit instead of arguing it, and use an affidavit. Y'all don't know how to use affidavits to support your facts. A lot of y'all just use it to say, well, I'm gonna put in an obligation. That doesn't move the court. That doesn't allow the court to move or request the court. I know a lot of people like, I'm not requesting the court. They don't got jurisdiction over me. And that's
Right.
and that's where a lot of y'all go wrong, because it's just so many things. And we're going to get into the investigative half of that as we develop this. I'm going to show you how to use freedom of information requests, how to collect your evidence before you go to court, and have an assortment, a variety of evidence that you can use to slam dunk the court and show, if you have a jury trial, how what they're using and how they're using this application of law that may not be applicable to you. But I digress.
All right. So we got like we got a few more minutes just to end this, so we can like show what the court basically um we're going with this. As further down, I look at this and I read. It says the state court held instead that the officer was lawfully confronting a possible hostile person in the line of duty. They're saying that he has a right springing only from the necessity of the situation and not from any broader right to disarm, to frisk for his own protection. This holding, with which I agree and with which I think the courts agree, offers only a satisfactory basis that can think of an affirming this conviction. The holding has, however, two logical corollaries that I do not think the court has fully expressed. So they're saying, in the first place, if the frisk is justified in order to protect the officer during the encounter with the citizen, the officer must first have constitutional ground to insist on the encounter, to make a forcible stop. Any person, including a policeman, is at liberty to avoid a person he considers dangerous. If and when a policeman has a right instead to disarm such a person for his own protection, he must first have the right not to avoid him, but to be in his presence. That right must be more than the liberty, where it says again, possessed by every citizen, to address questions to other persons and ordinarily the person. So, like, I mean, like, I see what their argument is on that. So, I mean, like, I'm just what I'm saying. Like, it's kind of it's kind of deep. Like, the argument in this case was, you know, does the officer have the right, if he feels like he's, um, you know,
Right.
endangered,
But
endangered,
is
or does he have the right to flee or get away from it? Like, it's got the
right,
right, and then so they determine it. Were you in a point where you had to do that, or what? So I mean, like the line, the thin line that this case had. That's why this case was really important, because it was so much argued in that, and there's so much like, because the police will argue some almost some irrational stuff sometimes. You know, the police will definitely lie to you. The police, have the right to lie. So they be coming up with all kind of stuff on why they did what they did. You know, the number one thing the police say is they fear for their lives. They always using they fear for their life. These are things that they're taught in academy, to how to write and talk, how to write and talk to get things in their favor. You know, so this is just something that's gonna be there. This is just something that you got to deal with police in general. They gonna lie to you off the rip, so that's why you really shouldn't talk to them. And they gonna lie in court. That's why you really got to be on your p's and q's. And then when they make that lie, it's got to be. It might have to be scrutinized. It has to be scrutinized. Like in this case, when you're looking at this, they talk about if the officers say, "Well, I felt endangered," so now they got to break down what that is. A lot of times, that's not what we're doing in court. Like we're not going into the nuke and the cranny. Like we're not breaking this stuff down. We're going in there and we're letting a lot of this stuff fly. We're letting a lot of what the officer says. We're allowing that to be used against us without really contesting it. You know what I'm saying? That's that's kind of what I'm getting from, or what I'm trying to portray to y'all.
That's why I talk about the interrogatories and admissions and the things so that you can see you want everything to happen, keep it in real time. So, because a lot of times, if you get the interrogatories and admissions early, a lot of times, say the case been going on 6 months, the officer changed his whole statement, right? He'll change his whole statement, but you already preserved the record of what he said. That's now is in the form of evidence that you already got when the first case first started in the pretrial phase. So now you already got that already established what he already said because that was earlier. Now you know that he's being contradictive. Now you can impeach his testimony. You can impeach him as a person because he just did what? He committed perjury. Lying is not a crime, but being perjurous is. So we got to learn how to combat these elements utilizing, because this is a strategy game. This is a game of strategy. So it ain't about just knowing the system or the legal, knowing the law. It's about how you strategize everything.
Facts.
You see what I'm saying? So that the court like to be very gibberish, long-winded when coming up with all of these scenarios. They always trying to find a nook and cranny because the officer never said about the stop and frisk. The court made that assessment, not the officer. The officer never, I guarantee he never used that term. The court came up with these terms. And this is the problem. We allow the court, instead of, that's why I say using the interrogatories, we make them stick to their statements and do not allow the court to improvise on their behalf.
Facts. That might be the next show, man. Interrogatories, breaking down interrogatories and the use of them. At least one of the shows we're gonna start. We're gonna get into
that. And that's what I find the problem with the court. I remember looking at the prosecutor when they're lost for words and they can't, and their case falling apart. They look towards the judge for assistance, and they do this all the time. Then you'll find the judge operating practicing law from the bench. I see this all the time.
right, but you'll be able to call it out. If you're able to see that, you'll be able to call it out, or you'll be able to, you use that in appeal, or use that in an injunction. You'll be able to use that.
Well, you can start showing bias and ask for a recusal based on those things. You can say, I'm gonna put in a motion for recusal, and now let me iterate this for the record, on the record. Here's the transcript, and this is why I want you off this case, Your Honor. You've been assisting the prosecutor. You provided me no kind of assistance, and it's evidence based upon the statements you have. Now you can ask for a recusal. Now you can hit him with a motion for recusal based on those grounds because he's practicing law for the bench, from the bench.
Right. I got you. Well, brother, I know I'm not gonna keep us on here all night, yo.
Oh, it's time for us to go, family. I'm supposed to been talking to some other people. So what I'm trying to get y'all to understand, when you know how to litigate, you know how to move around the courtroom, you have the legal prowess and the legal IQ. I tell people all the time, me and Chief been doing this for a long time. You're not going you're not going to have the legal experience. You can't buy it. You can take whatever documents or whatever, but you're not going to get what we got unless you've been through what we've been through. You've been in that courtroom. So on that note, I'ma digress. My closing thing I want to say: please subscribe, share, like. I'm gonna be posting this stuff. This is your boy King El Bey, dropping knowledge all day.
No doubt. Peace and love, family. Till next time.